I'm present, Your Honor. Good morning.
Morning, sir.
Thank you.
Mr. Samson Lebel,
I'm present, Your Honor. Morning.
Morning.
Your Honor, good morning.
Morning.
that's for the first respondent.
Can you communicate so that we move on? Yes. Or if your advocate is on the way, you tell us it's on the way. If you have no advocate, you tell us you're not represented. Oh no, I did not work. You have an advocate.
Your Honor, I'm not represented.
With an application just now. We'll be requesting an adjournment of 10 minutes. We look at the application, take instructions from our clients. Oh, sorry, sir. The state, there is a counsel here. So we're requesting 10 minutes to take instructions. Then we'll be able to know how to proceed.
The proper would be for each respondent to have a copy, then they can give their advocates as needed.
So that the advocate is supposed to share.
As we have only one.
And Miss Evelyn Onunga
Present, Your Honor.
for the Republic.
Mr. Chauvin, Ms. Grateful,
And Miss Evelyn Onunga, representing the Republic.
Mahari, that we give you 10 minutes break.
Yes, we can give them 10 minutes break. But there's someone else who needs to be put on Cora, my lady.
Your Honor, for the victim family.
Same is noted that the bridge will be adjourned for 10 minutes to enable all the parties familiarize themselves with the contents of the application before court, which I know has just been served in court. So we can just resume at 11.
Much.
Hearing at 11.
The whereabouts of our client, whether he is safe and alive, under what provisions is he kept without him being brought before this court or any other court, has no territorial jurisdiction. To entertain this matter, before the question about the applications before you are dealt with. You know, this is a matter of national and international public interest. Those two critical questions that we have placed before this court are so fundamental so, Your Honor, we will, because the state only needs to respond the whereabouts of Philip Aroko, then you allow us to deal with the question of whether the court has jurisdiction or it doesn't have jurisdiction. That's all, Your Honor, unless my other colleagues have issues.
All the respondents before you this morning were arrested yesterday, just like this Philip that we are talking about. Therefore, we should not be treated to piecemeal applications, because before you we have an omnibus file comprising of 5 respondents. And from the information that we have is that this respondent and that Philip are all connected to the investigations by the DCI over the loss of life of the Honorable Member of Parliament for Kasipur. We do know that this file has only 5 respondents, and this is a calculated move to use the Honorable Court in trampling on the rights of this Philip Aroko that we're talking about. To trample on the rights as obtaining in the Constitution, the right of that individual Philip that we're talking about. Again, we are going to raise before we start addressing you. Once the decision is made that you have the jurisdiction, we then address on that issue. I mean, when we deal with the issue of Philip, we'll address you on the issue of jurisdiction. Thank you.
The 4 suspects before this court.
5.
There are 5, sorry. And as you're aware, Your Honor, the name of one Philip Aroko is not appearing in the application. However, Your Honor, I have been informed by the investigating officer of this matter that indeed Philip Aroko was arrested yesterday night and was booked by OB number 2/8/05/2024 2025, sorry, 2025. I can repeat?
Yes.
That is copy number 2 of 0805-2025.
Yes. Kasarani Police Station. The law requires a suspect to be arraigned in court within 24 hours. The 24 hours given by the law has not elapsed. So this application is premature. I would like to urge the court to dismiss this application so that you concentrate on the application that is before court against the 5 suspects. Equally, on the issue of jurisdiction,
But if it says we did it, that then is the issue of jurisdiction.
Yes. We have not made our application.
or you've not made the application?
For
Okay.
jurisdiction, we have not made
You
our
have made-
application.
I will
It's
wait
about
for,
Aroko.
I will wait for the respondents to make the application. So I saw submit.
The state has not told you how a person we delivered as court officers to Gigiri police station. Live on all media houses was not booked at Gigiri police station and also booked out. That is a glaring either omission or intentional on the part of the state. To Your Honor, the state has not told you what time that OB was booked. The mischief, Your Honor, in this matter is that our client is being held away from courts so that we don't make an application for him to go and attend the burial.
Your Honor, I object. Let counsel respond to matters of law only. Yes.
Your Honor, read the mischief in this matter. That the state is not factual. Your Honor, the 24-hour rule is that if he surrendered at 10 p.m., he's supposed to be in court today. Failure to produce him in court today, the earliest time he'll be produced in court is on Friday at 9 a.m. earliest. Courts don't sit at night. His fundamental human rights of appearing before a competent court within 24 hours will have completely been abused and violated. And it's not accidental. It is to ensure he does not attend the burial.
Again, Your Honor, I object to that. Unless I'll be given time to respond to what
We have no
counsel is
problem.
submitting. No, that is not the law. That is not the practice. So let him restrict himself to the matters of law only. We'd like to save the court's time.
You know, I'm contextualizing the law of 24 hours to the fact. So, Your Honor, it is our submission that that person be produced before you today. Is him? The police have powers to release him. But as of now, there's a confirmation that is in police custody. The public and the country was worried whether that person is alive. We are seeking, let him appear before a court to confirm his health, to confirm he's alive. It is not the police who arrested the person. May the court order production of one Philip Aroko so that those two issues about his health, his life, to be dealt with. Mr. Cliff, finalize that.
Court. We expect that this being a court of law, it is the laws that govern and guide whatever comes forward. Prosecution wants us to speak law, let us speak law. They arrest some in custody and they don't want to tell you about it. So in totality what they are doing is they are going back on Article 19, which means that these fundamental rights, who do they belong to? Who do they belong to? They belong to an individual.
Your Honor, if I may, Counsel, I'm very sorry to interrupt. The fundamental human rights are dealt with at the High Court. This is not the proper court to handle such issues. So, it is not the proper forum to handle cases of fundamental human rights. We need your guidance, Your Honor, because if you are going this way, we are going to lose the court.
Your Honor, there's all matters of the Constitution and fundamental rights, and they are coming under Article 49. They bite and then they are blowing. How can they be hard to say that? They shouldn't then have brought this application under that article.
And Your Honor, there is no application before you. So what we are handling in this court is totally not before this court.
Your Honor.
So if the court is going to entertain any application in respect to that case, then I think it's, in all fairness, it will not be fair to the prosecution.
Your Honor, you're being told to shut your eyes. Let them not bully you about that. Let me say what I was saying quite clearly. If other persons... No, and that is the issue. When you bring others who were arrested yesterday and you don't bring him, there is something wrong somewhere. There is something wrong somewhere. Whether they are going to release him or not, bring him to court. That is the reason. So that this court can make that decision. And it is under the same constitution, under Article 20, whereby all the justice systems, the court, the police, and everybody is enjoined. All. It does not say the High Court only. All.
Let me just ask one question. Time of booking
My IOs, because this is not a matter that you are prepared to argue, so give me time to find out what time he was booked.
They came to court and prepared.
No, we didn't come for Philip Aroko. We came for the 5 suspects.
Because I know there's a difference.
At Kasarani police station. So Your Honor, you can compute if 24 hours are elapsed. And you can guide the prosecution on this.
My considered view is that time that the officers at the police station makes a decision to book and place in custody a suspect present at the police station. This is chiefly because not everyone presented to the police station is considered for booking in. In our case, Aroko was booked in at 12:18 a.m. On the morning of 8th of May 2025 by OMB number 02/08/05/2025, Kasarani Police Station. The Constitution provides for the rights of the arrested persons under Article 48, running through to Article 49 and 50 of the Constitution. Those rights flow through and through, since they deal from arrests and even rights of arrested persons and even rights of accused persons. And those rights follow each other. You cannot say that we can designate them. And so in this case, we note that one of the rights of an arrested person includes right to be presented before court as soon as possible, and in any event, not more than 24 hours after arrest, unless the next court date falls either on a public holiday or a weekend. In our case, since the time Philip Aroko was booked in custody by OMB number 20805 of 2025 at 12:18 a.m. on 8th of May 2025, 4 hours are yet to lapse. I therefore agree with the prosecution counsel that the said application is premature and the same is dismissed.
We are most obliged.
It is our submission that this court lacks jurisdiction to entertain the application before you, and we are grounding our application. Territorial jurisdiction. We are grounding our objection to this court proceeding to entertain any application before you as is obtaining in this file E081 of 2025 on account of provisions of section 67 of the Criminal Procedure Code. Section 67. This being a court of law, and it being guided by the procedural enactment of the law, you are stopped in your tracks to continue entertaining any application associated to the heinous murder of Sir Charles Were, MP Kasipul. Our reasoning is grounded on the following. The deceased Member of Parliament has had his working office at the Parliament buildings along Parliament Road in the CBD, Nairobi. We invite the court to take judicial notice that this deceased Member of Parliament was assassinated by unknown people at the Ngong Road roundabout. And therefore, the scene of crime is at the Ngong Road roundabout, whose area of jurisdiction ordinarily on the police territorial jurisdiction is the Kilimani police station. We do know that the homicide department has its offices within that said Kilimani area. And therefore, the way the courts operate, and alive to the provisions of Section 67 of the CPC, a proper court that should exercise jurisdiction over matters that arise within the local jurisdiction is the Kibera law courts, because Kilimani area is within the Kibera sub-county of the Nairobi County. Is within the Kibera sub-county of the Nairobi County. It therefore presents a case, a classic case, that this matter has been filed at the JKIA law courts for some mischievous ends. And I say so because if then the applicant, who is the DPP, was so convinced that Kibera sub-county or the Kibera court is not the one to handle, the next court is Milimani law courts, which is nearby. So why bring us all the way to the JKIA law courts if it is not an issue, and I dare say, an issue of forum shopping? We have competent courts at the Kibera sub-county. They are your colleagues, magistracy, in the magistracy, that is, at the Kibera sub-county. And in any event, if there is anybody to be charged after the conclusion of the investigations, that person can only be charged at the Kibera High Court. We therefore submit that you down your tools, you have powers within the law to order for this file to be transferred to the Kibera Magistrate Court, or at the very least, the Milimani Law Courts, for any processing of any application as may be intended by the DPP.
Provisions of transfer.
Those provisions of transfer are also encoded in that section 67 of the Criminal Procedure Code. There can never be an overlap in execution of duty when the law has spelled out in black and white where such applications have to be lodged. For the benefit of the court, allow me to read verbatim the provisions of that section. Accused person to be sent to district where offense committed. Allow me to read, it's 3-4 lines. Where a person accused of having committed an offense within Kenya has escaped or removed from the province, in this instance now the sub-county or district within which the offense was committed, and is found within another province or district, the court within whose jurisdiction he is found shall cause him to be brought before it and shall, unless authorized to proceed in the case, send him in custody to the court within whose jurisdiction the offense is alleged to have been committed, or require him to give security for his surrender to that court, there to answer the charge and to be dealt with according to law. Your Honor, we are submitting that kindly order for the transfer of the first respondent. If the rest of the respondents want to be in this bandwagon and the omnibus of the file, let them be processed by this court. But for the first respondent, the law stops you in the tracks and send this first respondent to the Kibera law courts for him to be processed over there. Needless to say that there are several authorities that have been presented and decided by the High Court, which are binding on this court, which my brother Cliff is going to address you on, so that then he gives credence to our submissions. Lastly, jurisdiction is everything, without which this court cannot act. And therefore, however much the court may, or the prosecution may want that this court, may want to imagine that this court has jurisdiction, you're not clothed with that kind of issue. Neither can you engage on a discretionary basis, much as we know that the Magistrates Court Act provides for jurisdiction of Magistrates Court within the Republic of Kenya. But when it comes to Section 67 of the CPC, please down your tools. I cede room for my colleague, Mr. Mbeta, to address you on the points of law.
Your Honor, for the DPP under Article 157 to be able to institute any proceedings, 157 of the Constitution, of the criminal procedure. No, an article of the Constitution, sorry. The state, the DPP must start the proceedings or initiate proceedings within the jurisdiction of where the incident has taken place. The only other alternative is where the person who has been arrested is situated. Under Section 71 and 72 of the Code, Criminal Procedure Code, the Director of Prosecutions has a statutory obligation to commence and institute any proceedings in terms of Article 157 of the Constitution within the local courts where the offense was committed, unless there are exceptional circumstances that exist to surrender it. So what are we saying here, Your Honor? Under the, unless there are exceptional circumstances that exist to surrender it. This was also confirmed and agreed to by Justice Nyakundi in Criminal Revision number 166 of 2020. This is a matter that I also attended in Malindi Court. 166 of 2020 at Malindi High Court. For the prosecution to be able to want to move a matter out of jurisdiction, they must first of all come and tell you why. they must give reasons. Today we are here in a matter whereby no reason has been given unless one is created imaginarily. Today.
Kindly counsel supply me that authority.
Decision.
Okay, they are being brought, I think. In a moment you will have.
In a minute.
Yes. Such that what you're being told, Your Honor, it's just like a lion in a cage. Within that cage, it's where it prowls. This matter did not happen in your jurisdiction. And if it did not happen in your jurisdiction, then the only thing that you can do, Your Honor, is to put the pen down, unless you have been given reasons. Jurisdiction is everything. Let me cede a little bit of my time to Mr. Wamboi.
Your Honor, first I will wish to be associated fully by the submissions made by my senior in urging you to down your tools, for you are left without jurisdiction, territorial jurisdiction for that matter, to deal with the questions raised before you. Your Honor, the authority of this court is not limitless. Your power flows either from the Constitution or statute. Statutes that are relevant in these proceedings, Your Honor, is the authority that you get flowing from the Magistrates Court Act of the year 2015, and the procedural law that guides these proceedings, flowing from the Criminal Procedure Code, Cap 75 laws of Kenya. Your Honor, that question about your power and authority is first meant to assist you in efficiently dealing with matters that arise around the court, the jurisdiction of the court, so that the court is not overwhelmed by issues that will ordinarily require determination arising from other areas where we have judicial officers to address those concerns. Secondly, Your Honor, the question about the effective exercise of the territorial jurisdiction of a court is purely one of perception. My seniors have mentioned that the first respondent, in a sense, feels that this court has been shopped for the purpose of giving orders without necessarily, Your Honor, that this court has been shopped for the purpose of issuing orders without necessary judicial review, miscellaneous application, number 84 of 2018. Judicial Review number 84 of 2018, decided by my Lady Justice P. Nyamoya, as she then was, now promoted to the Court of Appeal. The matter that involved businessman and politician Jimmy Richard Wanjigi. Your Honor, in this authority, you will note that whatever that is happening before this honorable court is not unique. Our friends from the office of the ODPP, in collusion with officers from the office of the Directorate of Criminal Investigations, have in the past attempted to dirty the streams of justice by playing these games that we are seeing today before this honorable court. The courts in the past have noted, and Your Honor, I will wish that you echo the sentiments of the good lady Justice, so that the annals of history can also remember you fondly, that indeed, Your Honor, justice in itself is not a cloistered virtue. Justice is not a cloistered virtue. That if we are not careful, justice will be denied to parties that deserve it, if we do not respect the letter and the spirit of the law. But if justice is done, Your Honor, and the public interest upheld, the public out there that are following these proceedings will acknowledge that indeed we have systems, we have laws that work and are meant to protect accused persons before the honorable courts. Indeed, Your Honor, just to quote my lady, the sons and the daughters of the land will dance and sing, while the angels in heaven will sing and dance. And the heaven and the earth will embrace, Your Honor. Allow our application direct that our colleagues, my seniors for the ODPP, do the right thing. Use this opportunity, Your Honor, to make heaven and earth embrace. That is all from me, Your Honor. Thank you.
To bring now the facts. I'm only giving now the facts of why jurisdiction is there. The first respondent is a director of the Lake Basin Authority, stationed in Kisumu. He is, and based on that, that's what my colleagues have laid to you, that this court, therefore, lacks jurisdiction. And sorry, Your Honor, I forgot to tell the court that he is the county UDA coordinator. So we are, my good Nyaberi brother is telling, read the mischief. The Aroko man we have been talking about is an ODM guy. Let the judiciary not be involved in politics. Aroko, you have already made that decision. I only wanted to tell the court that Aroko is a political aspirant in ODM ticket in Kaspur.
None of them were arrested, so I think.
So this one, I want to tell you that he's also in the political angle, being the UDA coordinator in Homa Bay. You wanna read that this is an attack on democracy. That's right.
Following.
Yes.
Yes. And they are saying that this case has no jurisdiction to handle. Either I take the file to Kibera, Roko, because it's near the supported scene of crime, or if not, so we remand it. But on the problem, you can still state that there's no problem, this case can still handle. I think one of the council said. So what's your opinion?
I agree with the councils.
What do you, no, there's one who said, but if you are still okay that the matter being tried here, it's still okay. So where are
I'm
you?
not okay with the matter being tried here.
So what are the reasons?
The way the council has said about the jurisdiction, I do comply with them.
And there is, in submissions, there is also one advocate who said that it can either be where the offense took place or where the suspect was arrested. They're saying that the court can also, if you also arrested here and there's a court there, you can also be taken there. There was also a submission to that. That either, it can either be where the offense took place or where you are arrested.
Where the offense took place.
So you are going by the where the offense took, not where you are arrested. Because the other thing is, I was arrested in JKIA, so I'm okay with being in JKIA.
Where the offense was.
So you're saying it's often because it was where the offense took place.
Your Honor, I underwent the difficult memory with those people who arrested me.
Don't object to that.
What they're going to do, at this point, there will be, if I say I'm jurisdiction, I don't know what I'll do. The issue surrounding how you got arrested while we are here will come to that. At this point, we're only dealing with the issue of whether the matter should be handled here or if I should transfer it to either.
Sex and medical attention.
Okay, okay. So you said you underwent? You said during arrest you underwent?
Brutality with the hands of those who arrested me.
Your Honor, we'll be mixing the two applications. I think let us deal with the jurisdiction
You
issue.
said you'll be seeking for medical attention.
Yes.
Maybe that's one time.
Okay. You can leave it as that, then you can seek for it later.
The rest of the responses are late in matters of law. So
And that's why I'm explaining. You can see what I'm. Because of that, according to because of that, the offense took place. That's okay. That's now following the discourse and what everyone is saying. Yes, what you or you still want to do.
Hapana, bali si mfanyika. Where the scene ni nani?
You're saying either?
Biro ni nani?
Alan Fahola. You as Alan, not what everyone is saying. What is your position? And what are the reasons?
I would request that this case be handled on matters jurisdiction. Reason being, it is because the incident, where the incident happened, it is easy to get the facts and even visit the scenes because it is within the jurisdiction.
You think facts and CCTV? Easier to get facts and? I think I didn't get the other one.
And even visit the scenes.
Or visit the scene.
Yes, ma'am.
Again, I will say that this application is premature. As much as I agree with the respondents that jurisdiction is everything, the persons before you are suspects. They are not accused persons. They are arrested persons. They have not been charged. If I refer the court to section 71 and 72 of the CPC, that was highlighted, of the CPC, 71 talks about ordinary place of inquiry and trial. This is not a trial. Of inquiry and trial. What has brought the prosecution before you is not a trial. The prosecution has come before this court under Article 49(1)(f), 49(1)(f) and G of the Constitution, and also 49(1)(f) and G of the Constitution, and also Section 36A of the CPC, which says remand by court. What the applicant is simply praying for before this court is for the extension of custodial orders. For detention, sorry. Thank you, Mr. Omari, for the guidance. Detention orders to enable the state conclude investigations.
I'm wondering whether that is it not going to the merits of what we are doing here? It's about jurisdiction. Now she's arguing about.
I'm in order because I'm informing the court why we are here. And I'm relying on the facts and the law that has brought us before this court. Your Honor, an offense can be committed anywhere within the jurisdiction, within Kenya. And as the law provides, even under Section 36A that I've just alluded to, if I may read, 36A1, pursuant to Article 49(1)(f) and G of the Constitution, a police officer shall present a person who has been arrested. Keyword here, a person who has been arrested. in court within 24 hours after being arrested. Your Honor, this is basically what we have done. And during investigation, Your Honor, a suspect may be arrested far from the place of the incident of the offense. Nothing bars the police from arraigning such a person at the nearest court. In order to adhere to the law. And from the nature of this offense, the preliminary investigation has established that it's a case of murder. Due to the complex nature of this case, more arrests are yet to be done. And nothing restricts the police officer from arraigning them anywhere near to the place of arrest.
Does this mean to arrest them near this spot than Milimani or Kibera?
What I am saying, Your Honor,
You're saying that they can be arrested anywhere.
yes,
The police can go anywhere,
yes,
especially near the point of arrest. So you're saying the five were arrested near Milimani and Kibera as counsel are
Your Honor, I would like leave that for you to determine as you make your ruling.
Yes.
I would like to make my submission that what is before you is just seeking detention orders. It is not a trial. Jurisdiction comes in when an accused person has been charged, and that is why this section this section 67 talks about accused person to be sent to the district, even though we no longer have district where offense was committed. The word there is accused.
67 CPC.
Yeah, 67 CPC. The key word there is accused. These are suspects. It's our submission that this application is well within this court, and this court has power to determine the application. As matters touching on jurisdiction only comes into place when it touches on a trial before a court, and this is not a trial, Your Honor. In cases such as this, evidence may be scattered all over. You may not find that orders are sought in one specific court. And I would like to say that the prosecution is not forum shopping, as has been submitted by the respondents. When the prosecution will make a decision to charge, the jurisdiction will be the High Court, which has unlimited jurisdiction. And the authority that has been relied upon by the respondents for the advocate for the first respondent.
Number?
I'll touch on them one by one, but generally what I would like to say is they are based on sound principle of law but they do not apply to this case, the circumstances of this case. Miscellaneous criminal application number 3 or 4 of 2016. This talks about a person who is, it talks about a person who has been held. 3 of miscellaneous criminal application number 3 or 4.
Your Honor, my senior is jumping the gun. These ones will be making reference to them in the event their application sees the light of day, which we don't.
But I have to touch on anything they have supplied us with. Nothing stops me from doing that.
The authorities we have supplied in relation to the
Criminal application number 3 or 4 of 2016 talks about holding charge. Totally? Yes? Let me respond. You'll have a right to respond, to reply. Some matter not touching on this case. And secondly, judicial review miscellaneous application number 84 of 2018. In paragraph 9, just to read that is in it's a quoted authority miscellaneous application number 58 of 2018, James Agri Orengo and 11 others versus Director of Public Prosecutions and 2 others. In this case, Your Honor, from the reading of this paragraph, there was summons that was requiring the applicant's attendance before the Chief Magistrate Court at Nyeri, in Nyeri, for purposes of taking plea. That was sought by the first and the second respondent. Again, does not apply to this case. As I conclude, Your Honor, the advocate for the first respondent has submitted that the first respondent is the Director of Lake Basin Authority and a presidential appointee. I would like to submit that everybody is equal before the law. All the respondents, the state is treating them the same. Irrespective of your social standing in the society. Lastly, I will not allude to the issue raised about politics. I have nothing before us to enable us to submit on that line. That is our submission. I am most obliged.
You are saying the court has restriction can proceed here?
Yes. Yes. Your Honor, on the outset, I'm supporting the DPP with regard to this application. It's good to state it from the outset. Your Honor, my colleagues, especially the advocates for the first respondent, has made heavy weather of section 67 of the CPC. Your Honor, the marginal notes of that section talks about accused persons. The persons before you are respondents. So that section does not apply. Your Honor, I have to cross-reference on application which you have already ruled on. That is a few minutes ago. They were demanding that Aroko be brought here.
You know, I didn't want to
Come on,
object.
come.
No, hold on. I didn't want to object, save that the court has pronounced itself on Aroko matter. The court is functus official. What we are seeking for is purely the question of jurisdiction. On the 5, not plus Aroko. That's.
You know, you are right. The court has pronounced itself on that.
Thank you.
I'm just cross-referencing.
So,
Yeah, that
if we bring Aroko here, it's okay, we can proceed.
No.
Yes.
That's not the issue.
Yeah.
If he was going to be brought here,
It was premised on the fact that there was an alleged violation of rights, and that particular individual was meant to be brought here quickly. So my colleagues are talking from the two sides of the mouth. Bring when they are brought. No, down your tools. Your Honor, I've just cross-referenced that, and it's true, as my learned colleague has said, you have already ruled on that. But you can take note of that kind of warped submissions. Your Honor, lastly, I would like the court to take judicial notice of another related application before this court, E077 of 2025, which this court granted the same orders that the ODPP is now seeking. Your Honor, taking judicial notice of that, we urge that you grant the prayers of the DPP, since they are...
Now we do have jurisdiction, because we are dealing with whether I have jurisdiction.
Exactly. But you have to take judicial notice of...
What I'm saying,
yeah.
You said I grant the application, but I thought we are yet to get the application. We are on whether I have jurisdiction.
Yes. And you can it's the same thing, Your Honor. You have jurisdiction and you must grant it. Since you've granted it before. Yes. You've granted it before. And you take judicial notice of the proceedings that I've just indicated. Lastly, Your Honor, Your Honor, that particular proceedings is coming before you on 5th. The same proceedings I referred to, on 5th of May. Lastly, Your Honor, 5th of June. Lastly, Your Honor, the advocates of the first respondent is actually urging this court to countenance the violation of the rights. And I want to explain of the respondents. They are submitting that you down your tools because you don't have jurisdiction, so that the respondents can go back with the police and then later on argue that their rights were violated because they were held beyond the same 24-hour rule.
How can you imagine?
The same 24-hour rule that they are making heavy weather of. Your Honor, I submit that you have jurisdiction. That's all.
A proceeding has been mentioned that this court had. If the question of jurisdiction was not raised, either due to the counsels who were present, I don't know if there were counsels, or the people who are unrepresented, failure to tell the court that it has no jurisdiction does not confer jurisdiction to a court. The court, on its own motion, on suo motu principle, could have refused that application. We believe the court dealt with that matter because the state never disclosed full disclosure of where the offense happened and which court has jurisdiction. That has been laid bare before you. So, Your Honor, it is our position that a court that has been dealing with matters, 1,000 matters, does not get jurisdiction by the number of cases it has handled. Jurisdiction is conferred by the Constitution and by statute. And we have demonstrated that. Number two, my good brother is telling you, if you don't deal with this matter, the respondents will be detained by the police. This court is above threats and intimidation. The court should stand firm with the law. If it has no jurisdiction, working hours for courts in this country start at 8 to 5. Courts with jurisdiction are sitting now. The courts are in operation, and the state ought to take these respondents to where the court has jurisdiction. Your Honor, an attempt for you to do an illegality is a serious, serious issue that each court clothed with jurisdiction deals and protects itself. Don't be told that the respondents will suffer. There is no great injustice than a respondent being dealt with at a court that has no jurisdiction. And lastly, my good sister, Madam Monunga, the DCI and the DPP are our friends, so the public might think that we are enemies. We are simply working. Let it go to the whole world that we work together with the DCI and work with the DPP. Save that them they are the other side, they are on that side and on this side. Ms. Onunga never told you which provisions deals with the respondents. They are talking that these are not accused people.
The application is brought under Article 49(1), 3 and Section
If you read it, it does not talk about respondents.
respondents are arrested persons.
Arrested persons, according to the law, is this a trial?
Treat them as arrested persons.
Very well, that's what I'm saying. Is this a trial? What is a trial? A trial is a competent court sitting, a competent DPP prosecutor sitting, a suspect, an arrested, an accused person. Otherwise, if it is not a trial, the DCI would have dealt with this matter administratively in the DCI offices. The moment they appear before a judicial officer, it is a trial. And that proceeding or trial, the court will be called to make a determination. Courts only make determination when proceedings continue and rules of procedure are followed in those proceedings, which is completely different from the Directorate of Criminal Investigations procedures, which fall under the police standing orders. We are before a constitutional organ called a court of law. You will hear us, you will make a determination. Your determination can be challenged to the High Court, to the Court of Appeal, and to the Supreme Court. What else can be said that is not a trial? The court will render its judicial mind on this matter. Judicial officers are to render their independent minds after hearing both parties. So, Your Honor, anybody trying to say these are arrested persons, entry of anybody to appear before you is an arrest. Entry for any person to appear before court in a criminal matter is an arrest. And that's what you are saying, that let the court exercise its mind. That these people before you are before you as people who deserve to be dealt with within the law. Mr. Mbeta will deal with it.
From the moment they are arrested. From the moment they are arrested. And they run so that we prevent this kind of problem that we are facing now. You're being told that the reason why we are blowing hot and cold is that You are demanding another person to be brought to court within 24 hours. Yes, we are demanding that he be brought to court before 24 hours.
My lady, are we still discussing jurisdiction here?
It is a point that they raised about my learned colleague, Mr. Apollo, raised, so I cannot let it slide. Yes. Had he been brought in this court today, Your Honor, that could not have stopped us from making this application that we are making now. We would have done it. But then, the authority I gave the court, that is number 166 of 2020. Elfek Osman versus Republic. If you go to page number 10, the second paragraph, and this is the judge's opinion, which then the state intentionally, and if not intentionally, by design, have avoided to tell you. And what does it say? The Director of Public Prosecution has a statutory obligation to commence or institute any criminal proceedings.
Paragraph 1 note 2.
Next, paragraph number 2, where it starts in intimately, in connected foundation, section 71 and 72. Is the doctrine of
What page?
It's 10. Yes. The Director of Public Prosecution has a statutory obligation to commence or institute any criminal proceedings in terms of Article under 157 of the Constitution within the local courts where the offense was committed. Obligation within the jurisdiction where it was committed. But what they forget is the next line. To give you exceptional circumstances. What have they given you as an exceptional circumstance? What have they given you? And Your Honor, they have given you nothing. Are these proceedings in a court? Yes, they are. And if they are in a court, which is the court that is supposed to have started these proceedings? We are saying the court that has jurisdiction, that is the one. That is why we are asking you, Your Honor, then what grants you the jurisdiction in this matter? Where do you get the jurisdiction? It is what they needed to give you to aid you to respond to that. They still give you nothing. Anything that comes to court must be tested. Whatever they say in the affidavit is tested. Whatever the IO and the prosecution give is tested. Is that not a trial? Are we not trying something? That is a trial by any way of imagination. My learned sister and good friend, Mr. Munga, said clearly that they agree that jurisdiction is everything. But she tells you this is premature. Yet, we have suspects in court. What is premature about it? Because in the first place, the commencement of this matter should not have been here. But now that they brought it here, what is premature about it? They just use words and tell you it's premature and leave it at that. And everybody's supposed to imagine. They're telling you the persons in the dock have not yet been charged. But Justice Nyakundi in that same application says a commencement of any trial of criminal proceedings. Is this a criminal proceeding? Yes. This Justice Nyakundi says that when the state wants to start any matter, the director of the statutory objection to commence or institute any criminal proceedings. Any criminal proceedings. It must be within that jurisdiction. Now we are saying, is this not a criminal proceeding? Did the DPP follow the rules of what he has said? An attempt has been made that anybody arrested with anywhere can be taken to court, even the nearest one. I want to just imagine that any of these accused person was arrested around JKIA. Your Honor, no. Not even one of them was arrested anywhere, even imaginary, around here. The respondent in court today, the first respondent in court today in this application, was arrested in Nakuru. They did not take him to a court in Nakuru. They rushed him to JKIA. Another one was arrested in Langata. Kibera is the nearest court, but they brought him here. And Your Honor, then that is why the questions are coming up. Why do they want to do this? Even when they know the law is clear, why do they want to do this? Your Honor, while we are saying that the suspects have been brought within 24 hours, isn't it also their right that they be tried within the jurisdiction that they are supposed to be tried? But my learned colleague, Mr. Apollo, watching brief for the family, yes, tells you that this matter, you have the jurisdiction. Where does he get that authority to tell you that? Because he did not quote anything, he just said it for the sake of saying it, just to feel that. He said it for the sake of saying it. Because if he had any backing, today Mr. Apollo, who I know and is my learned friend and a very good friend, I know him very good with the law.
But the court has handled a similar application.
Yes, I'm coming to that. And that is why I'm coming.
That by dint of that, I think I'm understanding that.
No, that's where I'm coming. That's where I'm coming, because I know him to be very meticulous, always with authorities, always with the law, and he carries them in briefcases. But today, he comes with an empty hand and tells you you have jurisdiction. And then he tells you you've handled the other matters before. Does that give him the right to just assume and tell you to do things for the sake of, or does it give you any jurisdiction? Either way, it does not work. And some of the authorities that I bring in court, he gives me. And then they give you two wrongs, and then they tell you that please proceed. Your Honor, they want you to just proceed. And you're being told by my learned colleague, Ms. Onunga, that evidence can be scattered all over. If evidence is scattered all over, is that the basis of jurisdiction? That is not the basis of jurisdiction. It is where the accused person is arrested or the scene of crime, not where evidence was found. That again is being said for the purpose of just emphasizing an non-existent law. Your Honor, and this I will say very humbly, because when we come to court, we come so that this court can arbitrate. And we come because we know that this court is a protector, not only of the persons who are in custody, but also of the law. So when you find a prosecution has come here and they are giving you stories that are not based on anything, And apart from quoting for you Article 49 and 36.
When I object, we're not giving stories. What I was highly counsel, please correct that. No stories. I cannot bring stories to a court of law.
The only one that was not was imaginative.
We don't give imaginations in court.
Yes, Your Honor, when you're told that evidence is scattered everywhere, what evidence did they even give you? If that is not an imagination. A good story. The DCI would have finished this matter at the station if it was that simple. But the reason why the law removes these things from them is so that they do not misuse that power of theirs. And now the DPP, when these gentlemen say they want to bring the case to JKIA, the DPP keeps quiet and says, yes, please proceed, it is okay. One time I used a word that everybody objected to when I said that they were behaving like rascals, and they said it was an insult. But the word rascal just means behaving in a cheeky way. And behaving in a cheeky way means you are disrespecting, because that's, those definitions, if you look at them, it means you are respecting. So when I say the DCI and the prosecution today are rascals, and the rascals are the DPP and the prosecution, let me allow Shadrach to proceed with the rest.
We can't allow Mr. Obeta to.
And the only reason for me, Your Honor, to rise is because I believe we are marking the waters for ourselves. You know, I say this because, you know, the days of finding ambiguity in statutes through the employment of semantics is long gone, Your Honor. And I say it's long gone because, Your Honor, the law has provided us with tools of statutory interpretation. And I am afraid what our colleagues in the DPP are doing are riding on the construction of statutories. Construction of statutes, Your Honor, sorry. That is finding the wording and the meaning of such words through reason and logic. They are telling you that simply because a statute does not capture the word respondent, then there is a lacuna in law. But Your Honor, if we go holistically,
when that was a bit misidentification, we call them arrested persons. We deal with them under the rights of arrested persons.
yes, Your Honor, I'm only echoing what my senior in the DPP was saying. And that is the reason why this court cannot apply Section 67, 71, and the subsequent sections of the CPC. Simply because there is no word as respondent in that statute. At this point, I wish to humbly say that I think they might have forgotten that in statutory interpretation, Your Honor, have what we call the legislative purpose. And the legislative purpose, Your Honor, goes on to assist us to understand the mind of the drafters, the problem posed to the mind of the drafters, and the solution of one. Your Honor, my colleague has directed this court to the heading of Section 71, which deals with the inquiry and trial. So I will pose this question to this Honorable Court, Your Honor, that if indeed the drafters of the CPC, in their own wisdom and the wisdom fetched anywhere else, so it fits to limit the exercise of arraignment of an accused person or any other person arraigned before a trial court, if they did not wish to limit the jurisdiction, that is the territorial jurisdiction of such court, then why are there the provisions of 67, 71, and 72 of the CPC? Your Honor, it has long been held that the rights of an arrested person being a right enshrined in the Bill of Rights.
Your Honor, I thought this had already been raised earlier.
Sorry, I'm just, Your Honor, it's, if the DPP can just follow my flow of thought. I'm trying to right a wrong here. Your Honor, if we go back, then this court is mandated to give an interpretation that gives the greatest benefit to whoever claims that right. And that is the right to a fair trial, expeditious, and the Honor will note that in the case of Republic Ex parte Wanjigi, that is application JR application 84 of 2018, which was given to you earlier. There is the citing of the case of the Union Bank of the Philippines and Desi Thomas. That is page. It's paragraph 62. I can't see the pages at the bottom or at the top, but at paragraph 62. There is the citing of the case of the Union Bank of the Philippines and Desi Thomas versus people of the Philippines, that says that the reason for this rule, that is the rule to try and hear any case within a proper territorial jurisdiction, the reason is first
right now. I need time to study them. So what I'll do, I'll deliver a ruling.
Oh, I'm so sorry, my Diana. What I wanted
is the entry point. You see if I have jurisdiction or not.
That is why I was.
If I have, I proceed. If I don't, I don't.
We totally agree with
Yes, but now I need time to look at these authorities and what both sides have stated. So I'll deliver a ruling on whether this court has jurisdiction or not tomorrow. That will be 9th of May at 10 a.m. What I want the guidance from the state is where we should remand, because I need to give an order for them to be remanded. I know in your application I have seen it. We
Yes,
understand that they be remanded at different police stations, but at this point we have to decide on what I'm giving custody of us or not. Can we put them in the same station?
Melody, they're already in different stations. We'd like that status quo to remain as such.
So the areas where each was.
Yes,
so we take them back to where they were for the night. Yes. Then tomorrow, depending on what the court decides, the court now will make a decision.
You know,
much obliged.
The families and the lawyers will want to know where they were. Let it be disclosed to the court so that it is known where they are, so that the families can go and see them.
Okay.
We have no objection for them being remanded where they were, but let it be public information.
You can just start with a Statutory, you can see if it's first respondent, second, and fourth. You take them back to the same station before now we go to the main application. First respondent. Where they were brought to?
Yes.
If I start with first respondent.
The first respondent was at Langata Police Station.
Langata?
Yes, Your Honor. The second respondent was at Gigiri Police Station. The third respondent was at Pangani. The fourth respondent was at Kiambu Police Station. Then the fifth respondent was at Embakasi Police Station.
So the first respondent and the remainder the police station, Pangani, Kiambu,
and in the meantime, you know, they can have access to family.
But I know when we are dealing with such high level cases, because I think it's not the first time I'm handling such high level cases, don't allow anybody to proceed. Yes. So even as Council Better says that a family be around, keep pushing. Don't allow anybody. And that's why sometimes we say, whoever wants to see them, kindly liars will say, not everybody will come to see such cases, especially when you do such cases. So kindly ensure that the person seeing you has been vetted by the for your own safety and security. As much as your advocates may want you to be seen by anybody, from where I sit, I'm safe. It's not safe. Let them pass through the aisle. Alternatively, the advocates will accompany the person for your own safety.
Much.
Okay,
Check it. Unasikia ni bei gani imepungua?
Funga.
Well, our client, the first respondent, was arraigned before this court. We have raised serious objections on the question of the law. That the law says somebody will be charged or be taken to court where the offense was committed. This offense of Mheshimiwa's death happened on Ngong Road. The court with jurisdiction is Kibera Law Courts. In Kibera, there is a magistrate. There are around 10 magistrates. Then we have the High Court. The people who murdered the Member of Parliament for Kasbul will be charged at Kibera High Court. The court has said it will go to render itself on that question, and we come tomorrow at 9. Serious issues affect 2 of our clients, one Philip Aroko and Ahashins. One, Philip Aroko was not brought to court. He is the most likely candidate on the ODM ticket to win the by-election that is coming. He has mobilized for three good years to be in the ballot in 2027. But fortunes have changed. He will be in the ballot after the IBC is constituted. He was selectively brought to be arrested. And he has not been brought today because we wanted to seek for bail for him to go and bury the late Member of Parliament. Philip is a member of ODM. The late Honorable Were was a member of ODM. Our client, Abel, is a UDA coordinator. He was appointed into the Lake Basin by the President of the Republic of Kenya, His Excellency Dr. William Ruto, because he worked for UDA. He is likely to be a candidate representing UDA in the by-election. The 2 of them have been selectively brought here so that, 1, they do not participate in the by-election. 2, they don't participate in the barrio. 3, according to our instructions, which we are relaying to the media, and which Aroko gave very clear instructions, the governor of Homa Bay, according to our client, is fronting for the son of the late Member of Parliament to be elected. This is why we are saying this is politics. The courts have no business dealing with political competition. It will not stop the 2 clans of us from being in the ballot. it solidifies their position of clinching the seat that has been left. But the two of them have given us instructions to pass the condolences to the family, to the larger Kaspool constituency, and to the country. And they are confirming they are not part and parcel of the murder or assassination of the Member of Parliament. They are not linked at all. The only link, which is very remote, is that they are going to contest political seats. We are urging the DPP, and we have instructions to write to the Director of Public Prosecution not to allow political fights to be used as, to be brought as criminal fights. The judiciary should be very alert that we are heading towards several by-elections, and very many aspirants are going to be dragged in court because they intend to contest the by-elections and the national elections that are coming in 2027. We confirm that our clans are as clean ni weupe kama pamba. Shida ni siasa. And those who are using the criminal justice system should be alert that this is not the first time. It started with Mandela in South Africa. He came out as a president. It went to Steve Biko. It moved to Mzee Jomo Kenyatta. It moved to retired President Uhuru Kenyatta. It went to the current president, William Ruto, at the ICC. The criminal justice system has never succeeded to stop political ambition. We are urging everybody to take notice that any time politics is being suppressed by a criminal justice system, the criminal justice system fails. And that's why we are putting the judiciary on high alert to allow our clans to be free. Aroko today was not brought. He'll be brought tomorrow. Tomorrow being the day for burial. So that as we make an application for bail, if he's granted application for bail, then we know how the choppers will take him to that place. In line with that, we filed an application to the High Court for habeas corpus, so that the violations being meted on our clans can be addressed. We expect the judge to give a bail so that our client, Aroko Philip, will be able to attend the burial tomorrow. My good brothers can also say one thing.
In court today. Number one, the respondents were arrested yesterday in relation to an investigation that is ongoing over the murder of Kaspool MP, the late Honorable Sir Charles Were, were arraigned. And they were arraigned by the miscellaneous application, where the state wants to have them for 30 working days. Number two, we brought to the attention of the court that last night we presented Philip Aroko to the Gigiri police station following a tweet that the DCI had sent out that he reports to the nearest police station. So yesterday, we presented him at the Gigiri police station at about 10 in the night. Shocker on us, this morning we've been told that they said Philip was taken to Kasarani police station, but nonetheless, he has not been brought to court. We raised that protestation that he ought to be with the rest of the team that was presented before court today, but the court overruled us and told us that before it we have 5 respondents, Philip not being one of them. We went ahead to object to the manner in which the state is presenting their evidence that they have jumped from Kibra, Lokot, which is the area within the scene of the incident. They jumped from Milimani and they brought these respondents all the way to this place. A ruling is going to be rendered tomorrow for that purpose. And as my brother has already said, we shall be following up these issues keenly. We are here to defend the respondents who have given us instructions, the two of them. And further to that, we shall be able to apply the provisions of the law, and we shall be fighting in court, and the fight that we are putting up in court is pegged on the law, nothing outside the law, and we are asking the court not to be put or pulled into the bandwagon of politics, because this is politics at play, and a member of parliament unfortunately assassinated. I sit ground to my colleagues to say whatever they have to state, then we'll proceed and finish up this issue.